Feels like I'm drinking J1s and H2As and what's a TN from this, and it's like drinking through a fire hose. And fortunately, we have a speaker here with us today that presented our first event virtually to talk a little bit more about the different types of visas, where they apply, some of the costs, timeline, structures to go along with that. But before I introduce Erin, I'd like to mention Ashley Lieberman on a video with GreenSeam talked about how cool it is when competitors in the industry can all come together and work together towards a common goal, and how amazing things can happen when doing so. You know, we focused a lot on the swine industry because that's what southern Minnesota has really built up the last 25 to 30 years. There's been a lot of challenges. As Joe talked about in that first session with the communities that he's been a part of, St. James and Medelia, it has not been easy. But they've learned a lot along the way. And part of what we're doing here by bringing all of you together is to learn about some of these case studies and some of these examples of, oh, that's something that might make sense, or maybe Diane's a resource for me, or maybe what's happening in this community is a great thing. It's one step in the right direction. And so thank you, Diane, for spending your time with us and sharing more about LB Pork and your story. Erin Schutte Wadzinski has an interesting story of her own, returning to Worthington. Erin's going to share a story, really talking about the pathways to a green card and citizenship, learning how to navigate that complex system of immigration law. Although this may not be directly focused on the TN and H2As and requirements as industry, please do use her as a resource as she is located in fairly close proximity. She is an immigration attorney and owns Kivu Immigration Law in her hometown of Worthington, Minnesota, where she returned. Erin earned her bachelor's degree from Yale and her law degree from the UConn School of Law. After working for 6 years in Yale's Office of International Affairs, she returned home to Worthington in 2018 to start her legal career in immigration law. Worthington's pretty heavy in a global workforce as well. She received the Initiator's Fellowship to launch Kivu Immigration Law, a social enterprise law firm that provides full representation of immigration-related legal matters for immigrants, their families, and their employers. Kivu Immigration Law is located in downtown Worthington and also serves clients virtually across several states. We're excited to have Erin and her husband move to Worthington and to apply her efforts and to really work towards the noble cause of helping and supporting this global workforce. So please help me welcome Erin.
All right, good afternoon, everyone. I just want to say thank you to Garrett for the invitation today, and it's so lovely to be part of an in-person event again. I feel like it's been a while. For those of you who don't know, Worthington is in the very southwest corner of the state. It's in Nobles County, so far bottom, second to the left county, about an hour and a half from here. What my bio doesn't say is that I grew up on a farm. So here I am as a kid. I grew up on a farm with pigs and cows and horses, and we grew corn and soybeans. And so this venue or these topics are really near and dear to my heart. There's a nexus between agriculture and immigration. And that's very apparent based on what Diane has shared with us today. Visas can be a bit of like alphabet soup, and we're hearing a lot of different letters thrown out. And what I hope to do in the next half hour or so is to zoom out and talk about how these foreign worker visas fit into the larger scheme of immigration law. So that way, if you work with foreign workers, you may be able to gain better insights into where they fall in this like murky realm of immigration. Next slide. So we're going to cover just a general overview of the U.S. immigration system. Like I said, we're going to zoom out. I agree with absolutely everything Diane said. It really seems like LB Pork is a leader in using a wide range of visas to really meet their needs in all levels of employment. So I applaud Diane and all of her efforts in navigating that complex process. I'm also going to provide just a few tips and suggestions on how employers can support immigrants in navigating their immigration journeys, whether that's in the employment-based track of immigration or perhaps in the humanitarian or family-based track. Next slide. So let's talk about American citizenship. If you were born in the United States, you are an American citizen. But if you were not born in the United States and did not derive citizenship from one of your American parents, you must obtain a green card, such as this one, in order to become a U.S. citizen. So this is an example of today's current green card. It's actually a little bit green, but next slide. An older one, and you can kind of just flip through these quickly, are all examples of permanent resident cards. This one here, the last one, is from the 1980s, and you'll notice that it doesn't even have an expiration date. So I have clients who have come to my office with a green card like this, and they've been permanent residents for like 40 years, and now they're ready to apply for citizenship. And I ask, why now? Why not 35 years ago? Half your lifetime ago. But I'm just glad that individuals are choosing to take that very last step in their immigration journey to become American citizens. Next slide. So, how to obtain a green card, because that is a required step in order to be able to apply for citizenship. You can obtain a green card through 3 different pathways: family-based immigration, employment-based immigration, and humanitarian-based immigration. And I'm going to talk a little bit about each of those tracks. Next slide. So family-based immigration is for individuals who have a family member who's a U.S. citizen or a lawful permanent resident. So that relative is going to be like the arm that will be able to bring them here or help them obtain that permanent residency card. Next slide. So with family-based immigration, there are kind of 2 different processes. There's one process for immediate relatives and another process for non-immediate relatives, who then fall into a preference category. So basically, the closer you are to that in relation to that U.S. citizen or lawful permanent resident, the faster it's going to be able to obtain that green card. So immediate relatives are spouses of U.S. citizens, children under 21, and parents of U.S. citizens. If you don't have that mom or dad or child over 21 or that spouse, you don't have an immediate relative. And if you have a brother, sister, or a lawful permanent resident, husband or wife, then you'll fall into a preference category. Sometimes it doesn't really matter if you are an immediate relative or permanent or in a preference category, but with a preference category, there are sometimes backlogs because your relationship to the petitioner, the permanent resident or U.S. citizen, puts you in a relational category. So, for example, there's a category of brothers and sisters to U.S. Citizens, and there's a certain number of green cards each year given out to brothers and sisters of U.S. citizens. Now, there are more brothers and sisters applying for green cards each year than there are numbers of visas available. So there's like a backlog that is like 20 years long right now for brothers and sisters to be able to get green cards. It's crazy. But if you have an immediate relative, say you fall in love with an American citizen and the American citizen can petition you as an immediate relative, that whole process can take just 1 to 2 years before you have a green card. So it varies drastically based on your relationship with a permanent resident or U.S. citizen. Here's an example. And because this is so complex, I like to give some kind of hypotheticals, so hopefully you can follow along a little bit. John was born in the United States. John's best friend is named Max. Max is from Mexico. Max introduced John to his sister Mary when Mary visited Max in the United States. Mary is a citizen of Mexico and entered the United States on a B1, B2 visitor visa that she received from the U.S. Embassy in Mexico City. When she entered the United States, she was only planning to stay for 2 months. Mary and John fell in love in the United States, and they can't imagine living apart. They get married in the United States. Now, can John submit a family petition for Mary? Is Mary eligible to adjust status in the United States? I'm seeing some nods. Yes. Anyone brave to tell me why? Why you think yes? Okay, maybe you'll be brave for the next example, but you can go to the next slide. So we know that Mary has an immediate relative because she is now married to a U.S. citizen. Next slide. And she has a lawful entry into the United States, which is really important when it comes to applying for a green card in the United States. And we know she has a lawful entry into the United States because she entered on a visitor visa. And even though a visitor visa cannot have, you can't have the intent to move to the United States when you come just for a visit, if something happens when you're in the United States that changes your intent, it's generally okay. So she's got that immediate relative, she's got that lawful entry, and unless there are other details in this example that we don't know, she's probably able to have her husband petition her and have her submit that green card application, which is called adjustment of status in the United States, all in one big step. So, good for Mary. Next slide. So let's talk a little bit about employment-based immigration. Now, many of the visas that Diane was talking about are temporary foreign worker visas, meaning that they generally do not provide a pathway to permanent residency, but instead are meant for someone to lawfully work in the United States for a particular duration of time. Now, permanent employment-based visas are visas that are, instead of having that family member as the arm to bring someone to the United States, there's an employer doing that job. So basically substitute the family member for an employer, and it's a very similar process. Next slide. In order to qualify for an employment-based green card, you have to fall into certain categories and meet certain requirements. The higher the level of education or the higher level of specialty, generally the easier it is to obtain an employment-based visa quickly. In this region, we see employment-based visas in the second and third categories, those who hold advanced degrees, or those who are skilled workers with some level of experience, or at a minimal, a college degree. And there are annual limits for how many visas are available for these types of green cards, but they're a more confident way to proceed in comparison to an H-1B visa, which is a lot of legwork as well, but is not permanent in the long run. So when someone is really serious about an employer, they will often take those steps, which can be lengthy and expensive, but ultimately will sponsor an individual who they are very confident in for that employment-based green card. You'll notice that there are a few details here that I'm not touching on significantly, but if you do know anyone who wants to invest nearly $1 million in a business, they could probably buy their green card that way. So we generally don't lead with that, but there are ways called through an EB-5 visa, which is like an investor visa. Okay, next slide. So let's talk a little bit more with an example here. Joshua works at Porky Farms in the United States. Joshua is a lawful permanent resident and has twin siblings, Kate and Mike. Kate and Mike are citizens of Mexico. They both speak English, have bachelor's degrees in animal science, and several years of relevant work experience. 7 months ago, Mike came to the United States without inspection and is living with Joshua. Kate has never been to the United States. Can Porky Farms sponsor Kate or Mike for an employment-based visa? Yes, you're brave.
Yeah, I would say yes to Kate, but no to Mike.
Why?
Because Kate hasn't come yet, but Mike came unlawfully.
Yes. So Mike has a little blemish in his immigration history because he has an unlawful entry into the United States. And without a lawful entry into the United States, you are not eligible to adjust status or apply for a green card in the country. I could lead a seminar on the few exceptions to that rule, but we're just going to go with that rule for now. Yes.
Can we do questions?
Go ahead.
Okay. So what if they came, what if they're here, I forgot how I was going to word this. So what if he went back and then they applied, they don't even know, if they don't know he's here without inspection, he went back to Mexico, then could he reapply?
So technically, once you've been in the country for more than 6 months and have accrued more than 6 months of unlawful presence, you trigger a 3-year bar when you return to that country or when you leave the United States. So technically, he would not be eligible to return to the United States for 3 years. And if he stays for a year after having entered without inspection and doesn't apply for any forms of relief, then he will be subject to a 10-year bar for re-entering. So if you overstay or accrue 6 months of unlawful presence, it's a 3-year bar. If you accrue 1 year of unlawful presence, it's a 10-year bar. Very, very severe forms of punishment. So, yeah, Mike has an issue with being in the United States and having entered without inspection, but Kate probably can. She probably could be petitioned for an employment-based green card if Porky Farms wanted to do that. What other options might either of them have?
Get married to a citizen.
Okay, so Mike could do that.
Would he have trouble then with a family-based visa if he had the illegal time here, or do they just kind of ignore that then?
So Mike would have to return to Mexico for his green card interview, because without a lawful entry, you cannot get a green card in the United States. So he would face that bar unless he would get a waiver. If he's married to a U.S. citizen, he would be eligible for a waiver, but his wife would have to explain what kind of extreme hardship she would face if he had to serve that 10-year bar. It gets complicated very quickly. So, entries without inspection and unlawful presence is really tricky to work around. And that's intentional with the way the system is created. Next slide. Oh, can you go back? Oh, no. Okay. So, next slide. So we got a little ahead. Consequences of unlawful entry. So you cannot apply for adjustment of status in the United States. You must return home to consular process, which is that interview at the U.S. Embassy. You're subject to a 3 or 10-year bar, potentially, and that waiver that I mentioned is called an I-601A waiver, where you need a qualifying relative to prove extreme hardship. and only spouses and parents are qualifying relatives. Next slide. So Kate may be eligible for an employment-based green card. Next slide. And also, Kate may be eligible for a TN visa. So the employer could consider a TN visa maybe before the petitioning her for a green card if the employer didn't want to make such a big investment and see whether Kate and the company were a good fit for each other. Next slide. Here's a list of professions that qualify for a TN visa. So Diane mentioned that there was a whole bunch of different types of professions that count. So not anyone from Canada or Mexico can come to the United States. You do have to have proper education credentials, which is generally a bachelor's degree in one of these fields. Okay, next slide. Let's go back to Mike for a minute. He's not eligible for adjustment of status through the employment-based or family-based track. He's kind of up a creek because he's accruing unlawful presence. But does anyone have any idea of what he might be eligible for? Okay. Pardon?
Refugee status for one reason or another?
So with refugee status, it's tough because you have to be designated a refugee in a third country, which would have to have happened prior to coming to the United States. But you're on the right track because if he fled Mexico, we don't know why he's here, right? Why Mike is in the United States. If he fled Mexico because he had experienced violence or harm or threats, he may have been escaping persecution. And that is a ground for asylum. So asylum, like asylees and refugees, have to prove that they have been persecuted based on race, religion, national origin, political opinion, or a particular social group. So you'd have to know more about Mike to know whether he might be eligible for asylum. Asylum seekers must apply for asylum within 1 year of arriving to the United States. So Mike has been here for 7 months. He needs to start acting on it if he's going to apply for asylum. Now, once you submit an application for asylum to the United States government, you are claiming persecution in your home country. And the process for having your asylum case heard, typically by an immigration judge and sometimes an asylum officer, it will probably take years given the extensive backlog in cases. So the federal government states that while asylum seekers are waiting for a decision on their asylum case, they can apply for work authorization. So 6 months after that asylum application is sent to the government, the asylum applicant or asylum seeker can apply for work authorization and get a work permit. And that's when they can go legally work in the United States for Diane or some other employer. And that's something that is really a game changer for many individuals who fled their home country due to persecution and are just seeking refuge, and to finally be able to achieve even a little bit of stability by being able to legally work in the United States. Like, it makes a big difference for the families, and it also makes a difference for our communities because it is expanding our local workforce. I represent a lot of asylum seekers, and so I see the difference on a individual basis, day by day, and it's one of the very rewarding parts of my work. So, you can next slide. Next slide. Other types of humanitarian track types of immigration benefits include a U visa, a T, so we haven't escaped alphabet soup forever. T visa, U visa, and VAWA. VAWA stands for Violence Against Women's Act, even though it's protection not only for women, it's for individuals who have been a victim of battery or extreme cruelty committed by a U.S. citizen or permanent resident spouse, or former spouse or other family member, basically a household member. A T visa is for victims of trafficking, either sex trafficking or labor trafficking. And it's good to remember that trafficking relates to someone crossing a border. So crossing a border for sex work or to be exploited by an employer. A U visa is more common than you might think. It's for individuals who have been a victim of a crime in the United States. And the type of crime, there's a list of what are qualifying crimes, but it ranges from like domestic violence to stalking to blackmail and things like that. And so those victims had to have been a victim in the United States to qualify for a U visa, which is different from asylum, because asylum, you're focusing on what happened before you came to the United States, and a U visa is something for victims that have been a victim of something bad in the United States. All of these types of applications do lead to permanent residency and U.S. citizenship if successful. And because they are part of the humanitarian-based track, they are eligible for adjustment of status in the United States, even if they don't have a lawful entry. So that's something that separates humanitarian track cases from family or employment-based cases. Next slide. Here's just a list of legal resources, trying to preempt some questions here. So I represent both individuals and employers on immigration-related legal needs, but it's not always necessary to have an attorney. Many individuals and many employers file applications pro se, like where they represent themselves. And for individuals who find the process a little bit too complicated for comfort, then there are some nonprofit organizations that can be resources, or attorneys who are in private practice. Attorneys' fees can get steep very quickly. One of my efforts in establishing Kivu immigration law as a social enterprise is to try and balance between being a private attorney in private practice, but then being accessible to individuals who are working class to lower class, new arrivals to the United States, and making sure that fees are accessible and affordable for all of them. So it's an interesting business model that has its own struggles, but one that has been working well for the past couple of years that I have been in business. Next slide. Okay. So, do we have time for any questions?
Sure do.
Okay.
Yeah.
So the general rule is that you must apply for asylum within 1 year of entering the United States, not within 1 year of falling out of status, but from arriving into the United States, or in other words, escaping your persecution. And the government will still receive an asylum application for individuals who apply after that 1 year filing deadline, but there's going to be an additional burden for the applicant to prove. And that burden will have to be to prove that there have been extenuating or changed circumstances in the home country, which makes them now fearful of returning, because now they fear that they will be persecuted, even if within that 1 year of arriving to the United States, they didn't fear that persecution. Does that make sense? Yeah. They're going to go through, so the applicant, the immigrant, will go through a very rigorous vetting process where, for any type of immigrant application that they're going to submit, they're going to be asked about their immigration history. Like, how many times have you entered the United States? What is your address history for the last 5 years? And when you sign the form, the applicant is signing that they are being truthful and providing accurate information. So that is expected of them, that they will disclose that information to the government. They will also likely have an interview with an immigration officer at their home U.S. embassy, where the officer may even ask for proof of residence during a certain period of time. So either like employment or school records from their home country, maybe tax records, or another thing in the past couple of years, the government has started like looking at people's social media accounts. So the government will be able to see like where you've been posting your pictures and stuff like that. So, it's hard to hide from the government. And, if individuals are trying to not disclose any presence in the United States, they're not the individuals that are coming to my law firm for assistance, or at least not to my knowledge. But I think it's very tricky to do. Okay. Well, thank you very much for having me.